Today's hearing is about the President's role in our constitutional system. Our system of government is a tripartite one, with each branch having certain defined functions delegated to it by the Constitution. The President is charged with executing the laws, the Congress with writing the laws, and the Judiciary with interpreting them. The Obama administration, however, has ignored the Constitution's carefully balanced separation of powers and unilaterally granted itself the extra constitutional authority to amend the laws and to waive or suspend their enforcement. This raw assertion of authority goes well beyond the executive power granted to the President and specifically violates the Constitution's command that the President is to take care that the laws be faithfully executed. The President's encroachment into Congress's sphere of power is not a transgression that should be taken lightly. As English historian Edward Gibbon famously observed regarding the fall of the Roman Empire, the principles of a free constitution are irrevocably lost when the legislative power is dominated by the executive. Although the President's actions may not yet amount to the executive's powers overtaking the legislative power, they are certainly undermining the rule of law that is at the center of our constitutional design. From Obamacare to immigration, the current administration is picking and choosing which laws to enforce. But the Constitution does not confer upon the President the executive authority to disregard the separation of powers by unilaterally waiving, suspending, or revising the laws. It is a bedrock principle of constitutional law that the President must faithfully execute acts of Congress. The President cannot refuse to enforce a law simply because he dislikes it. Certainly, presidents have from time to time made broad claims of executive power. However, assertions of executive authority have traditionally been limited to the area in which presidential powers are at their strongest, foreign affairs. The Obama administration, though, has been equally assertive in the realm of domestic policy, routinely making end runs around Congress through broad claims of prosecutorial discretion and regulatory actions that push executive power beyond all limits. Indeed, President Obama is the first president since Richard Nixon to ignore a duly enacted law simply because he disagrees with it. In place of the checks and balances established by the Constitution, President Obama has proclaimed that, quote, "I refuse to take no for an answer," end quote, and that, quote, "where Congress won't act, I will," end quote. Throughout the Obama presidency, we have seen a pattern. President Obama circumvents Congress when he doesn't get his way. For instance, while Congress is currently debating how to reform our immigration laws, the President effectively enacted the DREAM Act himself by ordering immigration officials to stop enforcing immigration laws against certain unlawful immigrants. When he couldn't get his preferred changes to the No Child Left Behind education law, he unilaterally waived its testing accountability provisions. When he objected to the work requirements in the bipartisan welfare reform law, he granted waivers that are specifically forbidden by the statutory text. Instead of working with Congress to amend federal drug enforcement policy, he's instructed prosecutors to stop enforcing certain drug laws in certain states and mandatory minimum sentences for certain offenses. And most notably, the President has, without statutory authorization, waived, suspended, and amended several major provisions of his health care law. These unlawful modifications to Obamacare include delaying for 1 year Obamacare's employer mandate, instructing states that they are free to ignore the law's clear language regarding which existing health care plans may be grandfathered, and promulgating an IRS rule that allows for the distribution of billions of dollars in Obamacare subsidies that Congress never authorized. The House has acted to validate retroactively some of the President's illegal Obamacare modifications. However, rather than embrace these legislative fixes, the President's response has been to threaten to veto the House-passed measures. The President's far-reaching claims of executive power, if left unchecked, will vest the President with broad domestic policy authority that the Constitution does not grant him. Those in the president's political party have been largely silent in the face of this dangerous expansion of executive power. But what would they say if a president effectively repealed the environmental laws by refusing to sue polluters, or the labor laws by refusing to fine violators? What if a president wanted tax cuts that Congress would not enact? Could he instruct the IRS to decline to enforce the income tax laws? President George W. Bush proposed, unsuccessfully, a reduction in the capital gains rate. Should he have instead simply instructed the IRS not to tax capital gains at a rate greater than 10%? The point is not what you think of any of President Obama's individual policy decisions. The point is that the president may not, consistent with the command that he faithfully execute the laws, unilaterally amend, waive, or suspend the law. We must resist the president's deliberate pattern of circumventing the legislative branch in favor of administrative decision-making. We cannot allow the separation of powers enshrined in our Constitution to be abandoned in favor of an undue concentration of power in the executive branch. As James Madison warned centuries ago in Federalist Number 47, the accumulation of all powers, legislative, executive, and judiciary, in the same hands may justly be pronounced the very definition of tyranny. It's now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, and a good morning, top of the morning to the witnesses and to my colleagues on the House Judiciary Committee. The President's constitutional duty to faithfully execute the laws would be an important issue worthy of a hearing by this committee if there was any evidence that the President has indeed failed to fulfill his duty. But unfortunately, it appears that some here view policy disagreements as constitutional crises and proof of possible wrongdoing. The fact is that disagreements or even allegations that a program is not being carried out the way Congress intended should not raise constitutional concerns. If some of my friends want to disagree with the administration, it's of course certainly their right. But we should keep some perspective here and consider the following issues. To begin with, some of the administration's actions criticized by the majority are not really that much out of the ordinary. Allowing flexibility in the implementation of a new program, even where the statute mandates a specific deadline, is neither unusual nor a constitutional violation. It is rather the reality of administering sometimes complex programs. This has been especially true in the case of healthcare legislation. The Affordable Care Act is not the first time implementation of a new law has not gone according to schedule. President George W. Bush, for example, failed to meet some of the deadlines in Medicare Part D, even though it was legislation he strongly supported. And it's especially interesting that some members who strenuously oppose the Affordable Care Act and who work diligently to obstruct its implementation now complain that the President is unconstitutionally impeding the implementation of his signature legislative accomplishment. How interesting. Taking steps to deal with the realities of implementation of a complex program hardly constitutes a failure to take care that the laws are faithfully executed. It is rather part and parcel of doing just that. There have been administrations in the past that have obstructed the implementation of laws they opposed. But no one is seriously contending that President Obama opposes the Affordable Care Act, Obamacare, or that his administration's actions constitute intentional obstruction of the law. And when in the past there have been legitimate concerns about delays in the law's implementation, parties have turned to the Administrative Procedure Act. That act allows that courts determine whether a delay is unreasonable and order appropriate relief. Notably, no one has alleged that such action is necessary here. Instead, critics of President Obama and his signature legislation allege a constitutional crisis. But no court has ever found delay in implementation of a complex law to constitute a violation of the Take Care Clause. Now, some of my colleagues seem to think that the exercise of prosecutorial discretion, a traditional power of the executive, is a constitutional violation. The decision, for example, to defer deportation of individuals who were brought to the United States as children who haven't committed felonies or misdemeanors and do not pose a threat to public safety, so-called dreamers, is a classic exercise of such discretion. The administration cannot legalize these individuals' status without a basis in law, but the administration's decision to defer action against particular individuals is neither unusual nor unconstitutional. The Supreme Court has consistently held that the exercise of such discretion is a function of the President's powers under the Take Care Clause. For example, in Heckler versus Cheney, the court held that an agency's refusal to institute proceedings shares to some extent the characteristics of a decision of a prosecutor in the executive branch not to indict, a decision which has long been regarded as the special province of the executive branch, inasmuch as it is the executive who is charged by the Constitution to, quote, take care that laws be faithfully executed, end quote. Finally, I hope we can distinguish between failing to execute the laws and following the explicit dictates of the law. Some here contend that the President's decision not to defend the Defense of Marriage Act violated the Take Care Clause. In fact, the President made a judgment subsequently vindicated by the United States Supreme Court that the act was unconstitutional. But while the case was pending, he continued to comply with the law. The President's decision not to defend the law was not novel. Indeed, Congress itself recognized this possibility. Congress understood that sometimes the administration's duty to take care that the laws be faithfully executed might include recognizing that a particular statute is unconstitutional. The Constitution is, as we are told in Article 6 of the Constitution, the supreme law of the land. Presidents are required to follow it. So, past administrations have exercised their discretion not to defend a law while that they have deemed unconstitutional. For example, the acting Solicitor General at the time, John Roberts, now the Chief Justice of the United States, refused to defend a law that he believed to be unconstitutional in the 1990 case of Metro Broadcasting versus the FCC. Chief Justice Roberts argued that a statute providing for minority preferences in broadcast licensing was unconstitutional. Despite Supreme Court precedent applying a more permissive standard of review, he argued that strict scrutiny applied. Senate legal counsel appeared as amicus curiae to defend the law and prevailed. Clearly, there were reasonable arguments that Chief Justice Roberts could have made in defense of the law, yet no one suggested that he violated the Constitution by arguing for the court to strike that law down. His view was not vindicated in that case, but may ultimately have resulted in a shift in the law which makes it additionally clear that the administration's decision not to defend DOMA was neither unprecedented nor inappropriate. And so I join with all of the committee in welcoming our witnesses, look forward to their testimony, and I yield back the balance of my time, Mr. Chairman.
Thank you, Mr. Conyers. Without objection, all other members' opening statements will be made a part of the record. We welcome our panel of witnesses today, and if you would all please rise, we'll begin by swearing you in. Do you and each of you swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that all of the witnesses responded in the affirmative. Thank you. And I'll now begin by introducing our witnesses. Our first witness is Jonathan Turley, the Shapiro Professor of Public Interest Law at George Washington University Law School. Professor Turley is a nationally recognized legal scholar who has written extensively in areas ranging from constitutional law to legal theory to tort law. He has published over 36 academic articles and over 750 articles in newspapers, including the New York Times, USA Today, and the Wall Street Journal. Professor Turley has been recognized as the second most cited law professor in the country. Our second witness is Nicholas Rosencrantz, a professor of law at Georgetown University Law Center. Professor Rosencrantz has served and advised the federal government in a variety of capacities, including as a law clerk to Supreme Court Justice Anthony Kennedy and as an attorney advisor to the Justice Department's Office of Legal Counsel. He has published numerous scholarly articles, including The Subjects of the Constitution, which is the single most downloaded article about constitutional interpretation in the history of the Social Science Research Network. Our third witness is Simon Lazarus, a senior counsel with the Constitutional Accountability Center. He is a member of the Administrative Conference of the United States and during his career has served as the Public Policy Counsel for the National Senior Citizens Law Center, as a partner at Powell Goldstein, and as Associate Director of President Carter's White House Domestic Policy Staff. Mr. Lazarus has written articles that have appeared in law journals as well as publications such as The Atlantic, The Washington Post, and The New Republic. Our final witness is Michael Cannon, the Cato Institute's Director of Health Policy Studies. He has been recognized as an influential expert on the Affordable Care Act. Mr. Cannon has appeared on ABC, CBS, CNN, and Fox News and has written articles that have been featured in numerous newspapers, including the Wall Street Journal, USA Today, and the Los Angeles Times. He is also the co-editor of a book on replacing the Affordable Care Act and the co-author of a book on health care reform. I'd like to thank all of the witnesses for their appearance today. Each of your written statements will be entered into the record in its entirety. I ask that each witness summarize his or her testimony in 5 minutes or less. To help stay within the time frame, there is a timing light on your table. When the light switches from green to yellow, you will have 1 minute to conclude your testimony. When the light turns red, it signals that the witness's 5 minutes have expired, and we'll turn first to Professor Turley. Welcome.
Thank you, Mr. Chairman. Ranking Member Conyers, members of the Judiciary Committee, it's a great honor to be invited to speak with you today about the meaning of the Take Care Clause. You have to forgive my voice, I'm getting over a cold, but I hope to make it through this without having a coughing fit. This is obviously a difficult area of constitutional interpretation. As the Ranking Member pointed out, this is not the first time that we have dealt with this question. It is also difficult for some of us who happen to agree with the President's policies, which I do. In fact, I voted for him previously. However, in a Madisonian system, it is often more important how you do something than what you do. And the reason this is such an important hearing is that the bedrock of our Constitution remains the separation of powers. It is often misunderstood as some type of conflict between the branches. It is really a protection of liberty. It allows for issues that divide us to be cycled through a system in which factional interests can be transformed. Even though all branches are equal in the Madisonian system, the Congress is the thumping heart of that system. It is where issues that are divisive are transformed into majoritarian decisions. It is the very reason that our system has survived so well. It brings stability to the system. Benjamin Franklin used to say, or liked to say, that God helps those that help themselves. In our system, in the Madisonian system, the Constitution helps those branches that help themselves. It is designed to give each branch the ability of self-protection, of self-defense, and a great deal rides on the use of that power. In my view, some of the questions we're going to talk about today are close questions. Things like internet gambling, drug enforcement. I think you can have credible arguments on the administration side, but some of them I believe are not close questions. I believe the President has exceeded his brief. The President is required to faithfully execute the laws. He's not required to enforce all laws equally or commit the same resources to them. But I believe the President has crossed the constitutional line in some of these areas, which I address in my testimony. What I want to start in my opening statement is to emphasize that this is not a turf fight between politicians. Rather, this goes to the very heart of what is the Madisonian system. If a president can unilaterally change the meaning of laws in substantial ways or refuse to enforce them, it takes offline that very thing that stabilizes our system. I believe that members will loathe the day that they allowed that to happen. This will not be our last president. There will be more presidents who will claim the same authority. When I teach constitutional law, I often ask my students, what is the limiting principle of your argument? When that question is presented to this White House, too often it's answered in the first person, that the president is the limiting principle, or at least the limiting person. We can't rely on that type of assurance in our system. So the greatest danger of non-enforcement orders is not what it introduces to a tripartite system, but what it takes away. What it does is it allows for these issues that divide us to be resolved unilaterally. We don't have a dialogue anymore if someone can step in and make the legislative process simply an option as opposed to a binding stage or requirement. It is here in Congress that factional interests coalesce and convert. This is the transformative branch. It's different from the other branches, and that's what makes this so dangerous. What Madison did is he created a type of Newtonian orbit of branches. In fact, he was very interested in Newton's physics when he wrote much of the early writings. There's a belief that these are three branches that exist in orbit. They're held together by their gravitational pull. It's a delicate balance, but it's one that protects individual liberty. Federalist 51 is one of the most cited sources for Madison's views. It is in that writing that he encouraged branches to be on guard for the encroachment of their powers. For decades, this Congress has allowed its core authority to drain away. I've written a lot about the rise of what is called the fourth branch, this expanding number of federal agencies that are acting increasingly independently, even defining their own jurisdiction. If that trend is to continue and the president's powers to continue to expand, Congress will be left like a Maginot Line on the constitutional landscape, a sad relic of what was once a tripartite system of equal branches. There are times like this one of bitter intractable divisions, but the members of this body are tied by a covenant of faith, an article of faith. And it is found in Article 1 that says that all legislative powers herein granted shall be vested in the Congress of the United States. It is upon that covenant that we shouldn't divide by parties, and we should stand firmly for the separation of powers.
Mr. Rosencrantz, welcome.
Thank you, Mr. Chairman, Representative Conyers, members of the committee. I thank you for the opportunity. Mr. Chairman, Representative Conyers, I thank you for the opportunity to express my views about the President's constitutional duty to take care that the laws be faithfully executed. I quite agree with Representative
You better check your microphone and pull it closer to you.
Can you hear me now?
Yeah, pull it real close, though. That'll work very well.
Sorry. So to speak about the Take Care Clause, I want to associate myself with Professor Turley's opening statements. I quite agree with all of his remarks. I'd like to just draw the committee's attention to the text of the clause. It's always best to begin by parsing the actual words. So first, notice that this clause is not a grant of power, actually, but the imposition of a duty. The President shall take care. This is not optional, it is mandatory. Second, note that the duty is personal. The execution of the laws may be delegated to other officers, but the duty to take care that the laws be faithfully executed, that's personal. That is the President's duty alone. Third, notice that the President is not required to take care that the laws be completely executed. That would be impossible given finite resources. The President does have power to make enforcement choices. However, he must make them faithfully. Finally, it's important to remember the historical context of the clause. English kings had claimed the power to suspend laws unilaterally, but the framers expressly rejected that practice. Here, the executive would be obliged to take care that the laws be faithfully executed. So with these principles in mind, it's possible to view some recent controversies through this precise, proper constitutional lens. For this purpose, I'm going to focus on three examples. The President's unilateral decision to suspend certain provisions of the Affordable Care Act, the President's unilateral abridgment of the Immigration and Nationality Act, and on the IRS's targeting of the President's political adversaries. So first, the Obamacare suspension. On July 2nd, 2013, just before the long weekend, the Obama administration announced via blog post that the President would unilaterally suspend the employer mandate of Obamacare, notwithstanding the unambiguous command of the law. The statute is perfectly clear. It provides that these provisions become effective on January 1st, 2014. The blog post makes no mention of the statutory deadline. This raises the question of what it means to take care that the laws be faithfully executed. Certainly the adverb faithfully gives the President broad discretion about how to best deploy his executive resources. And the scope of that discretion can be the subject of legitimate debate. But this is not a mere calibration of executive resources. This is wholesale suspension of law in the teeth of a clear statutory command to the contrary. Whatever it may mean to take care that the laws be faithfully executed, it simply cannot mean declining to execute a law at all. Now, the President's remarks on this issue were quite striking. A few months ago, he said he would actually prefer to simply call up the Speaker of the House to request a change in this law that would have achieved the desired delay. But the truth is, he wouldn't have needed to pick up the phone. The House actually had already passed the Authority for Mandate Delay Act, but the President, far from welcoming this legislative change, actually threatened to veto it. So this seems almost like a willful violation of the Take Care Clause. Now, the second example, the Immigration and Nationality Act suspension, which the chairman mentioned, I'll just mention briefly. What's striking about this is the President's decision to enforce the immigration laws as though the DREAM Act had been enacted, when in fact it has not. So in this case, it's almost a mirror of the other case. Rather than declining to comply with a duly enacted statute, the President is complying meticulously, but with a bill that never became a law. Congress has repeatedly considered a statute called the DREAM Act. The President favors this act. Congress repeatedly declined to pass it. So the President has simply announced that he would enforce the Immigration Naturalization Act, Nationality Act as though it had been, as though the DREAM Act had been enacted. To put the point another way, the President's duty is to take care that the laws be faithfully executed. Laws, capital L, not those bills which fail to become law, like the DREAM Act. Finally, I'll just briefly mention the IRS targeting. If the adverb faithfully means anything, I would say that it means non-discriminatorily. That is, the President cannot enforce the laws in a discriminatory manner. And the story of the IRS targeting is actually the application of the tax laws to the President's political enemies in a discriminatory way. This is perhaps the single most troubling type of enforcement discrimination. And so in a way, perhaps the most troubling violation of the President's obligation to take care that the laws be faithfully executed. Thank you.
Thank you. Mr. Lazarus, welcome.
Thank you very much, Mr. Chairman, and thank you, Mr. Ranking Member Conyers, and all the members of the committee who are here. I'm afraid I'm going to have to disagree with my colleagues on the panel who have spoken so far. Brandishing the Take Care Clause has become a favored talking point for opponents of an array of Obama administration policies and actions. All of these efforts, or at least the ones with which I'm familiar, are in reality all these efforts to import the Constitution into what are in reality political and policy attacks are really rhetorical make-weights. They mock the text and original meaning of the Take Care Clause. They flout long-established Supreme Court precedent, and they contradict the consistent practice of all modern presidencies, Republican and Democratic, to implement complex and consequential regulatory programs, as Congressman Conyers pointed out. These critics fault the Obama administration for many things, but essentially two kinds of things. One, making necessary adjustments in timing of implementation of laws, and particularly the Affordable Care Act, and secondly, in matching immigration enforcement priorities with available resources and practical humanitarian and other exigencies. But exercising presidential judgment for such reasons is precisely what the Constitution requires. It is precisely what the framers expected when they established a separate executive branch under the direction of a nationally elected president and charged him to take care that the laws be faithfully executed. So let's first take a quick look at one of the targets of these charges, and that is the phasing in of the ACA employer mandate, which has been called a blatant illegality and many other things, but in fact, it's a routine temporary course correction. What exactly did the administration do? On July 2nd, it announced the decision to postpone for 1 year the January 1, 2014 effective date for the ACA requirement that large employers provide their workers with health insurance or pay a tax. This and other subsequently announced delays related to the ACA do not constitute refusals to enforce the ACA at all. On the contrary, they are merely phasing in adjustments designed to ensure effective implementation of the overall statute in accord with Congress's purposes. The Treasury Department's announcement makes that clear, and the proposed regulations that it has followed through on September 5th make that clearer, as does the Treasury's statement that it intends to continue fine-tuning those regulations and working with the people affected by them until they become finally effective. And I should emphasize that just after the administration took this action, President George W. Bush's HHS Secretary Michael Leavitt concurred that, quote, the Obama administration's decision to delay the employer mandate was wise, unquote. That was based on his experience in phasing in the Medicare Part D prescription drug benefit. So I have to say that hyperventilating about how extraordinary and unprecedented and unconstitutional these delays are is just that. It's hyperventilation, and it's contrary to obvious historical fact. Nor is the one-year delay of the employer mandate an affront to the Constitution. The framers could have prescribed simply that the President execute the laws. So why did they add faithfully and take care? And I have to disagree respectfully with Professor Rosenkranz and Professor Turley about their explanation of the history and original meaning of the clause. Obviously, they were taking pains to clarify that the President's duty is to implement laws in good faith, hence the word faithfully, and to exercise reasonable care, hence the word take care, in doing so. The fact is that scholars on both the left and the right concur that this broadly worded phrasing means that the President is to exercise judgment and to handle his enforcement duties with fidelity to all laws, including, indeed, the Constitution. As a legal and a practical matter, the President's phase-in of the employer mandate and other ACA provisions is well within his job description. So is the DACA program, the Deferred Action on Childhood Arrivals. I'm not going to go into that now, but Congressman Conyers explained why that's true, and in my written statement we do so also. I have to say one quick word about what I know that my a good friend and frequent debating partner, Michael Cannon, is going to focus on, and that is his theory, and he gets credit for a lot of credit for thinking it up and marketing it. His theory that Affordable Care Act premium assistance tax credits and subsidies must be available to all, his theory that they are only available to Americans who happen to live in states that have set up their own exchanges. I can't go into detail about this. Unfortunately, perhaps in the questioning I'll be able to do that. But his theory is that a few phrases in this enormous statute have to be construed in a way that would stiff millions of people who were the intended beneficiaries of the Act. Am I over? I'm over. The fact is that that is not the correct construction of the Act, and perhaps we'll be able to talk about that further.
Thank you, Mr. Lazarus. Mr. Cannon, welcome.
Thank you.
You want to put that microphone on and
Thank you,
hold it
Mr.
closer.
Mr. Conyers and members of the committee. I want to start off by saying that the concerns that I'm going to be sharing with you today are not born of partisanship. It's no secret that I have worked for Republicans. I myself am not a Republican. I'm acutely aware of the last Republican president's failure to execute the laws faithfully. In 2008, though I supported neither major party presidential candidate, I actually preferred Barack Obama to his opponent, in part because he promised to curb such abuses by the executive. And I've praised President Obama for doing more than even many libertarians to celebrate the gains in equality and freedom our nation has secured for women, for African Americans, for gays, and for lesbians. Article 2, Section 3 of the Constitution, to which every president swears an oath, commands that the president shall take care that the laws be faithfully executed. Fealty to this duty is essential for maintaining our system of government and public order. The law is a reciprocal pact between the government and the governed. Public order requires government to remain faithful to the law as much as it requires a citizenry to do so, because if the actions of government officials lead citizens to conclude that those officials are no longer meaningfully bound by the law, then the citizens will rightly conclude that neither are they. Since he signed the Patient Protection and Affordable Care Act into law, President Obama has failed to execute that law faithfully. The President has unilaterally taken taxpayer dollars made available by the PPACA and diverted them from their congressionally authorized purposes toward purposes for which no Congress has ever appropriated funds. He has unilaterally and repeatedly rewritten the statute to dispense taxpayer dollars that no federal law authorizes him to spend, and that the PPACA expressly forbids him to spend. He has unilaterally issued blanket waivers to requirements that the PPACA does not authorize him to waive. At the same time, he has declined to collect taxes that the PPACA orders him to collect. He has unilaterally rewritten the statute to impose billions of dollars in taxes that the PPACA expressly forbids him to impose, and to incur billions of dollars in debt that the statute expressly forbids him to incur. He has unilaterally rewritten the PPACA to allow health insurance products that the statute expressly forbids, and he has encouraged consumers, insurers, and state officials to violate a law that he himself enacted. And he has taken these steps for the purpose of forestalling democratic action by the people's elected representatives in Congress. President Obama's unfaithfulness to the PPACA is so wanton that it is no longer accurate to say that that statute is the law of the land. Today, with respect to health care at least, the law of the land is whatever one man says it is, or whatever this divided Congress will let him get away with saying. What this one man says may flatly contradict federal statute. It may suddenly confer benefits on favored groups or tax disfavored groups without representation. It may undermine the careful and costly planning done by millions of individuals and businesses. It may change from day to day. This method of lawmaking has more in common with monarchy than with democracy or a constitutional republic. This president's failure, or any president's failure, to honor his constitutional duty to execute the laws faithfully is not a partisan issue. The fact that presidents from both parties violate this duty is cause not for solace, it is cause for even greater alarm, because it guarantees that presidents from both parties will replicate and even surpass the abuses of their predecessors as payback for past injustices. The result is that democracy and freedom will suffer no matter who occupies the Oval Office. I thank you, and I look forward to your questions.
Thank you, Mr. Cannon. I'll begin the questioning under the 5-minute rule. Professor Rosenkranz, oftentimes the legislative process is about negotiation, about give and take between competing interests and compromise. How does the president's creating, amending, suspending, and ignoring acts of Congress at will affect the legislative process?
That's a great question, Mr. Chairman. The short-term effect is an aggrandizement of the president, but a predictable long-term effect is legislative gridlock. There's every reason to believe that Congress will not be able to reach these compromises if they know that these compromises can be unilaterally rewritten in the White House. Every reason to believe that Congress will grind to a halt under the threat that President Obama will rewrite its handiwork.
In fact, couldn't you argue that that is indeed happening right now, that as you try to work out differences between various perspectives on a piece of legislation, those who may be asked to give something that they think the president agrees with them on might say, well, why should I give on that because I can get that changed or done unilaterally by the executive branch, and therefore, or the party that wants to achieve that says, well, why should I agree to it because they're not going to enforce that anyway.
You could imagine such a negotiation about the effective date of Obamacare, but after the statute is passed, President Obama decides what the effective date is, quite regardless of what Congress wants. So gridlock is quite a predictable result.
Professor Turley, the Constitution's system of separated powers is not simply about stopping one branch of government from usurping another. It's about protecting the liberty of Americans from the dangers of concentrated government power. How does the president's unilateral modification of acts of Congress affect both the balance of power between the political branches and the liberty interests of the American people?
Thank you, Mr. Chairman. The danger is quite severe. The problem with what the President is doing is that he's not simply posing a danger to the constitutional system. He's becoming the very danger the Constitution was designed to avoid. That is the concentration of power in any single branch. This Newtonian orbit that the three branches exist in is a delicate one, but it is designed to prevent this type of concentration. There's two trends going on, which should be of equal concern to all members of Congress. One is we've had the radical expansion of presidential powers under both President Bush and President Obama. We have what many once called an imperial presidency model of largely unchecked authority. And with that trend, we also have the continued rise of this fourth branch. We have agencies that are now quite large that issue regulations. The Supreme Court said recently that agencies could actually define their own or interpret their own jurisdiction.
I'm going to cut you off there because I've got a couple more questions I want to ask and only 2 minutes left. But Mr. Cannon, You've argued that the President is going to spend billions of dollars Congress did not authorize to provide premium assistance tax credits and subsidies on federally run health care exchanges. Could you please quickly walk me through why the President's plan to provide premium assistance on federally run exchanges is indeed illegal?
Well, we call those premium assistance tax credits because that's what the statute calls them, but in effect they are government subsidies, they're government spending. And the statute is quite clear, it is consistent, it's unambiguous, it was intentional and purposeful. When it said that those premium assistance tax credits would be available to only to people who purchase health insurance through an exchange, quote, established by the state under Section 1311. That's not just one mention of that phrase. The phrase is mentioned several times explicitly and through cross-references. The statute is very tightly worded, and it makes clear that those tax credits are available only if a state establishes an exchange itself under Section 1311. If the federal government establishes a federal fallback exchange, those tax credits are not available because that exchange is established by the federal government under Section 1321, as the Obama administration has acknowledged in regulation.
Thank you. I agree. Professor Rosenkranz, some defenders of the President's unilateral actions have asserted that his actions were merely an exercise of prosecutorial discretion. Are these assertions correct, or is there a fundamental difference between prosecutorial discretion and many of the President's unilateral actions?
So there are many cases that are close cases. I agree with Professor Turley, but some of these cases are not close. So prosecutorial discretion is one thing, but wholesale suspension of law is quite something else, and that is what has happened under Obamacare. Likewise, in the immigration context, kind of case-by-case prosecutorial discretion is one thing, but a blanket policy that the Immigration Act will not apply to 1.8 million people, that's quite something different. This is a scale of decision-making that is not within the traditional conception of prosecutorial discretion.
In fact, the President has taken it a step further and has actually given legal documents to the people in that circumstance, well beyond simply deciding not to leave them there and not prosecute them, but actually enable their violation of the law by giving them documents to help them evade the problems that ensue from living in a country that they're not lawfully present. Is that
quite right?
Correct?
Let these leaders be mindful that our families are here.
President, we do not have order in the hearing room. Members of the audience must behave in an orderly fashion.
We pray for immigration to find solutions for these leaders. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us today our daily bread, and forgive us our trespasses. Against us, lead us not into temptation.
I have conferred with the ranking member and simply afforded them that opportunity earlier in the hearing. Now they're going to be required to leave.
Well, my passion is those who are leaving. I hope that we will come to an understanding of our hearts.
Out of order. My time has expired, and the chair now recognizes the ranking member for time for his questions.
Thank you. I'm interested in the presentation of Professor Lazarus, who was explaining some of his differences with the witness to his left. And I would like to ask if he could pick up that line of discussion. We're pleased that you're here because there's been so much excitement or excited rhetoric about where the President and his administration are going. I've never heard this level of hypothesizing as to where this is all going to take us, and I think it's considerably over the top. I'm so glad you're here today, and I'd ask you to respond, please.
Thank you very much, Mr. Conyers. The theory of that the Affordable Care Act actually intended to cut off the very benefits that the law was passed to create, to the very core constituency of needy people that was the target of the law that my friend Mr. Cannon came up with is something that no one on either side of the aisle had any idea about when the law was passed. He and some other clever colleagues came up with this theory at least 9 months, I think, after the law was passed. And the fact is, and they were very happy that they did so, they have gloated that their theory, if adopted by the courts, would drive a stake through the heart of Obamacare, that's their words, that it would sink the ACA and threaten its survival. In fact, however, the law's text does not sabotage the universally acknowledged purpose of ensuring access to health insurance for all the millions of Americans who cannot now afford it. To make their implausible case to the contrary, Mr. Cannon and his colleagues snatch a few isolated words out of context and ignore the rest of this huge statute. But if you look at the entire statute, you quickly have to conclude that the whole text, not just these isolated phrases, harmonize the purpose of the statute with its text and mean that all Americans who are eligible for the benefits to enable them to afford insurance will be able to have them whether or not they reside in federal exchange states or state exchange states. And I want to add just one quick thing, and that is, so Mr. Cannon and his friends soon realized that their reading of the text didn't make sense and hang together. So they came up with an even more head-scratching claim, and that is that the sponsors of the law, quote, intentionally and purposefully designed it to achieve this self-immolation. Mr. Cannon just referred to that argument. So what this means, it means that the ACA sponsors actually intended not only to stiff the very people that they wanted to benefit, it actually means that they intentionally handed over to Mr. Cannon's allies in state capitals the stake that he talks about and invited them, if they chose to do so, to drive it through the heart of the ACA. I mean, we have to imagine, really, in order for your theory to make sense, one has to imagine Senator Baucus, Senator Murray, Senator Reid, that well-known soft touch, Senator Schumer, getting together in a floor in a room off the Senate floor and saying, I know what we're going to do. We're going to enable all the Republican governors and state legislators just to decide that the ACA won't work in their states. Unsurprisingly, there's not a single piece of evidence in the legislative record to support this notion. What is really going on, I'm afraid, is that having lost politically, having lost in the Supreme Court, the ACA opponents who are clinging to this theory are hoping that the courts will bail them out once again. That's an awfully big political lift. I don't think that the courts are going to do that.
Thank you so much. Mr. Chairman, I would ask unanimous consent to put in the record this report by the New Republic of November this year entitled Obamacare's Single Most Relentless Antagonist, who is our distinguished witness here today.
I think
reserving, can I just ask one quick question, Mr. Chairman? Is the New Republic doing reports or articles?
Reports or articles? I can't tell you. You mean on the one that I'm introducing?
Yes, Mr. Ranking Member. I only ask because I'm fine to have newspapers and op-eds and so on put in the record. I just want to have them characterized not as a report, as though they have some substantive factual backing.
Well, I've never been asked this question before.
Well, only because I'm often called the president's antagonist, and I'm not sure that a report that left me out would be justified as factual.
Well,
without objection, the New Republic article entitled Obamacare's Single Most Relentless Antagonist And I'm sure both the author of the theory with regard to the federal use of those funds and the gentleman from California would both be proud to have the article in the record, and therefore we will, without objection, make it a part of the record.
And I'm sorry to disappoint my friend, whose name isn't even mentioned in this article.
An oversight.
Thank you, Mr. Chairman.
The chair recognizes the gentleman from Texas, Mr. Smith, for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, in my judgment, the President has ignored laws, failed to enforce laws, undermined laws, and changed laws, all contrary to the Constitution. It seems to me that the President is trying to make laws by executive decree at news conferences. But in a 2012 interview, the President said that he could not, quote, wave away the laws that Congress put in place, end quote, and that, quote, the President doesn't have the authority to simply ignore Congress and say, we're not going to enforce the laws that you've passed, end quote. Yet it seems to me that is exactly what he has done. I'd like to address my first question to Professor Turley, Professor Rosenkranz, and Director Cannon. I think I know their answer, but the question is, do you think, in fact, the President has acted contrary to the Constitution? Professor Turley, you mentioned that you supported the President's policies and even voted for him, yet you say he has crossed the constitutional line, the legislative process is not an option, and what the President has done is dangerous. So I assume your answer is yes, the President has acted contrary to the Constitution. Is that right?
It is, and I would also just add, Congressman, that this was an issue that the framers considered, 150 years before they drafted this provision, which didn't change much in the committee. This was a fight with James I, and the framers were very familiar with it, and I think that's what gave life to this very clause.
Thank you. And Professor Rosenkranz, do you think the President has acted contrary to the Constitution?
Representative, I would say that some of these cases are close cases, but some are not. So the wholesale suspension of law, for example, is, I would say, the paradigm case of a take care clause violation, yes.
Okay, thank you. And Director Cannon?
Yes.
That's quick and easy. Thank you. My next question is a little bit tougher, and that is, what can Congress or the American people do about it? How can we restrain the President from acting in a way contrary to the Constitution? And Professor Turley.
That is, I think, the most difficult question that we face. I've had the honor of representing members of both parties of Congress in going to the courts, and the courts are quite hostile towards members standing, for example, when they believe a violation of the Constitution has occurred. It is, in fact, members standing that would solve many of our problems. That is, if members could go to the courts and raise violations of the Constitution, that would be, it would make much of these difficulties go away. You'll note that the administration has made reference to the fact, and I think they have some support for this, that they doubt people would have standing to challenge many of these acts. So we have the framers would never have accepted that you can have violations of the Constitution, yet literally no one can raise the issue successfully with the courts for review.
Okay, Professor Rosenkranz.
Well, I'm actually not sure I agree with Professor Turley on the standing question. It's quite true that some of these violations may not be amenable to judicial review. Ultimately, though, the check on this sort of constitutional violation is elections. So this is exactly the sort of hearing we ought to be having, exactly the sort of hearing that the electorate ought to be paying attention to for our next round of elections.
Okay, thank you. And Director Cannon.
I think there's little that Congress can do if it is divided over the President's abuse of his authority. But fortunately, and as far as judicial remedies go, it's very difficult to challenge an action of the President when he relaxes an obligation on a certain party. It's much easier to find a plaintiff who has standing to challenge an action that imposes new obligations that the legislature never approved. That is what has happened in the case of the President issuing premium assistance tax credits through federal exchanges, because those tax credits will trigger tax penalties on employers and individuals in those 34 states that have refused to establish an exchange. And a number of those employers and individuals, including 2 state attorneys general, 15 Indiana school districts, and a dozen or more private employers and private citizens have filed suit for 4 different lawsuits. In fact, one of them will have oral agreements this afternoon here in Washington, D.C. So there is judicial remedy for some of these abuses.
Okay, good. Thank you, Director Kennan. Thank you, Mr. Chairman. Yield back.
Chair now recognizes the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you, Mr. Chairman. Mr. Lazarus, Professor Rosenkranz has written in a Wall Street Journal op-ed piece that Abraham Lincoln would not approve of the delay in the employer mandate and contrasts this decision with Lincoln's suspension of habeas corpus. Could you comment on the claim that Lincoln would disapprove? And what about the contrast with suspension of habeas corpus by Lincoln?
Yes, I read that article with some amusement, I have to say, Professor Rosenkranz. I think that President Lincoln would chuckle somewhat contemptuously at the notion that there is an equation between suspending the writ of habeas corpus, perhaps the most fundamental guarantee of freedom in our whole system, with a temporary delay in the implementation of a regulation that's of a provision that's part of a very complex new law, which is something that happens under all administrations. It has to happen sometimes for practical reasons. Why we are making a big fuss about this as a constitutional matter, well, it's not beyond me. I understand why it's being done. If it sounds like politics, that's what it is. But to make that kind of a comparison, Professor Rosenkranz, doesn't do justice, I think, to your position at Georgetown.
May I?
Thank you. No, I have too little time for too many questions. Let me start by saying that I generally, in many respects, agree with Professor Turley about the growth of the imperial presidency over the last half century or more. I'm particularly concerned about the abuse of the war powers by many presidents, the use of the state secrets doctrine to prevent enforcement of constitutional rights, the dragnet surveillance that we've seen under Bush and Obama beyond the contemplation of the Patriot Act, warrantless surveillance in the Bush administration, and things like that. I must say that everything we're talking about today is laughable, in my opinion, in the context of these problems. I'm particularly struck by the overwhelming hypocrisy of the claim that the president, in interpreting the law, in refusing to interpret the law in a way that would drive a stake through the law, is not enforcing the law. In demanding that he enforce the law on the dates in a way that the person making that demand says would destroy the law, is not taking care of the law to be faithfully executed. I would say it's the other way around. That it's the duty of the president to interpret the law within the boundaries that he has in a way that makes practical the implementation of the law to effectuate the will of Congress. And the fact that people who want to sabotage the law and want the law not to work and make no bones about it say, hey, he's not obeying this particular sentence in order to make the law work. Talk about hypocrisy. Let me ask a question, having made my statement. I want to ask Mr. Lazarus the following question. There's Judge Kavanaugh in the District of Columbia Circuit recently, in a decision by Judge Kavanaugh, recently wrote the following. The executive's broad prosecutorial discretion and pardon powers illustrate a key point of the Constitution's separation of powers. One of the greatest unilateral powers the President possesses under the Constitution, at least in the domestic sphere, is the power to protect individual liberty by essentially under-enforcing federal statutes regulating private behavior. More precisely, the power either not to seek charges against violators of a federal law or to pardon violators of a federal law. Now, this would seem to support broad discretion in the executive branch to set enforcement and therefore non-enforcement priorities of drug, immigration, and other laws. Does it not? And how does that relate to the alleged violation of the Constitution by the President in setting immigration enforcement priorities, as was outlined earlier?
Well, thank you very much, Congressman Nadler. And of course, what Judge Kavanaugh, who is one of the most respected and most conservative judges on the federal bench, what he said here is absolutely correct. And the principles that he's enunciating are precisely why a court, if faced with the issue, would undoubtedly uphold as perfectly compatible with the President's discretion in the immigration area in particular, the DACA program that my co-panelists here are claiming is a gross violation of his duty to see that the laws are faithfully executed. I'd like to, if I can, just quote one other authority, and that is the Supreme Court. In an important decision about a year and a half ago, a 5-3 majority, including Justice Kennedy, who wrote the opinion, and Chief Justice Roberts, opined that, quote, a principal feature of the removal system in the immigration area is the broad discretion exercised by immigration officials. Federal officials, he said, as an initial matter, must decide whether it makes sense to pursue removal at all. And they went on to say that discretion in the enforcement of immigration law embraces immediate human concerns. Unauthorized workers trying to support their families, for example, likely pose less danger than alien smugglers or aliens who commit a serious crime. Now, that very recent broad-based decision, like Judge Kavanaugh's remarks, is completely at odds with the critics' cramped interpretation of the President's immigration enforcement and his constitutional authority.
Well, I wanted to ask Mr. Rosencrantz to ask if he agreed with Judge Kavanaugh and the Supreme Court if I'll ask unanimous consent for one additional minute so Mr. Rosencrantz can answer that, Mr. Chairman.
Without objection, the gentleman will have additional 1 minute. Mr. Rosencrantz.
I'm glad you asked, because Judge Kavanaugh also said quite recently in 2013, quote, the President may not decline to follow a statutory mandate or prohibition simply because of policy objections. Of course, if Congress appropriates no money for a statutorily mandated program, the executive obviously cannot move forward. But absent a lack of funds or a claim of unconstitutionality that has not been rejected by final court order, the executive must abide by statutory mandates and prohibitions. I think Judge Kavanaugh is exactly right.
Of course, that's not the question. The question was delay here. But thank you.
Chair recognizes the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. Mr. Rosencrantz and Mr. Cannon, Mr. Lazarus had commented upon previous writings of yours, but you weren't afforded the opportunity to respond. Did you want to take a moment to do that? I'll go with you first, Mr. Rosencrantz.
Yeah, thank you so much. So there was a comment about an op-ed that I wrote in the Wall Street Journal comparing Lincoln's suspension of habeas with President Obama's suspension of Obamacare. Of course, I agree with Mr. Lazarus that these things are not the same. Habeas and Obamacare are not the same. But what is striking about the comparison is that President Lincoln welcomed the involvement of Congress, welcomed Congress to ratify what he had done, to pass a statute justifying what he had done. He was concerned that perhaps he had overstepped his constitutional authority. He welcomed Congress's ratification of his action. President Obama, by contrast, actually threatened to veto a statute that would have ratified his action. That, I think, is the startling contrast that I was trying to bring out in that op-ed.
Thank you, Mr. Cannon.
Well, Mr. Lazarus, and whenever this issue comes up of whether premium assistance tax credits are authorized in the 34 states with federal exchanges, supporters of the administration of the IRS's decision to offer them in those states with federal exchanges talk a lot about what Congress must have been thinking or could possibly have been thinking, or would they have done this. And there's a reason they do that. It's because the statute is clear and it contradicts what the Obama administration is trying to do. And unfortunately for the administration, the legislative history also is completely consistent with the clear language of the statute. They have offered, despite 2 years of people like me raising this issue that what the IRS is trying to do is illegal, they have yet to offer one shred of one statutory provision or one shred of evidence from the legislative history that supports their claim that this statute authorizes tax credits through exchanges established by the federal government under Section 1321, or that it was Congress's intent for this statute to authorize tax credits through those exchanges. So there's a lot more to be said about all of this. If I may, I'd like to respond to something that Mr. Adler...
Let me cut you off at this point. Okay. I've only got a limited amount of time. Mr. Turley, let me ask you this. You had mentioned something along the lines of you were concerned that President Obama is becoming the very danger that the separation of powers was meant to prevent. Mr. Lazarus mentioned earlier that I don't know who exactly he's referring to, but some are hyperventilating about this whole topic. Would you want to comment on both of those things, either in relation to each other or not?
Sure. Mr. Lazarus may be responding to my labored breathing with the flu, but it's not my testimony. The reason I think that we have this disconnect in our view of this clause is that we obviously read the history differently. I view the Constitutional Convention is quite clear. The framers were students of history, particularly James Madison. 150 years before they took a pen and wrote out this clause, there was a fight with James I about what was called the royal prerogative. It's very similar to what President Obama is claiming, the right of the king to essentially stand above the law, to reform the law to the king's views. Now, I'm not saying that President Obama was a monarch, but that was the issue that gave the impetus to this clause, in my view. The language of the clause did not change very much. Later, people like Benjamin Civiletti dealt with this under a different term, the dispensing power of the president. And Civiletti wrote a very good paper about when the president could refuse to enforce laws. And he basically said that it could only be done where there is an intrusion upon executive power. And by the way, that's what was involved in the Myers case that we talked about, referred to earlier. Or if it was clearly unconstitutional. And that second issue, he established it had to be very, very clear so the president does not exercise dispensing authority. So this is how I would respond. We don't have to hyperventilate to look at a problem of this kind and say that this is not about who the president is today or what he's trying to achieve. What is lacking from the other side is any notion of what the world will look like in a tripartite system if the president can literally ignore any deadline in a major piece of legislation, exclude whole classes of people from enforcement. The question is, what is left in that Newtonian orbit that Madison described? And I would suggest what's left is a very dangerous and unstable system.
Thank you very much. My time has expired. Yield back.
Chair recognizes the gentleman from Virginia, Mr. Scott, for 5 minutes.
Thank you, Mr. Chairman. Mr. Lazarus, first of all, on the ACA, it seems to me absurd that the federal exchanges that are there for all intents and purposes to serve as the state exchange or state marketplace, it would be absurd to interpret that they're there for all intents and purposes except for the purpose of the bill, which is the subsidies. Is that right?
It's obviously absurd, Congressman Scott, and therefore to say that the president is violating his duty to see that the law is faithfully enforced because he interprets the law in a way that is consistent with its purpose and consistent with the known objectives of the Congress that enacted it is also, it seems to me, quite absurd.
Thank you. The Congressional Research Service provided several examples in prior administrations where the IRS delayed enforcement despite a congressionally mandated effective date. Can you say a word about the President's power to delay implementations of provisions, particularly when compliance is logistically impossible?
Yes, and I think actually, despite the sparks that are flying around this room about the President's actions with respect to the Affordable Care Act, these principles are really quite simple. Several people have noted that the President cannot refuse to enforce a law for policy reasons. That's obviously correct, certainly correct, and it's also obviously not what the President is doing. Does the President have policy objections to the Affordable Care Act? I don't think so. Phasing in the enforcement of major statutes like the Affordable Care Act or the Clean Air Act or other laws, certainly laws that the EPA administers, miss statutory deadlines very, very frequently because it's simply logistically impossible to prudently implement them in accord with those deadlines. This is just a tempest in a teapot.
Thank you. And
if I can say one further thing about your first question, Congressman Scott, we should understand what the consequences of Mr. Cannon's interpretation of the ACA would be, and why it would drive a stake through the heart of the ACA in every federal exchange state. It's not just that it would keep maybe 80% of the people who are expected to enroll for insurance on exchanges from being able to afford that insurance, 80%. So it would really wreck that part of the program. But actually, it would probably just cause the entire individual insurance market, even for people who could afford insurance, to implode, because it would so screw up the actuarial calculations. So it really would drive a stake through the heart of the law in those states, and to say that Congress intended to do that is I don't know. It's just pretty hard to stomach.
Thank you. In November 1999, 28 bipartisan members of the House wrote the Attorney General a letter and expressed concern that INS was pursuing removal in some cases, quote, when so many other more serious cases existed. How do you set priorities? If the president can't set priorities in enforcement, when there's obviously not enough money to enforce each and every provision to the letter of the law, how do you set priorities if he can't enforce each and every provision?
The answer is it's the essence of the executive responsibility to do just that. And I might note that I think that President Obama has increased the number of deportations, to the consternation of some of his own supporters, a very great deal, as everyone here I'm sure is well aware. And my understanding is he's increased it to 400,000 people a year, which is like nearly 4 times as many as the number was around 2000. And the reason for that is that that's all the funds that Congress has appropriated for that.
My time is about to expire. I wanted to get in one other question. Can you talk about the obligation of the president to defend Defensive Marriage Act when he believes it to be unconstitutional?
Yes, I think I agree that the president should only very, very rarely and with extremely good reason decline to defend a law in court, and I've written about that. And I think it's hard to fault what the president did in the case of DOMA. He concluded with very good reason that there was simply no argument that could justify DOMA. He notified Congress of this decision. He continued to enforce it. He invited Congress to intervene in litigation to present that point of view. And ultimately, the Supreme Court vindicated his judgment. So it seems to me it's very difficult to complain. Everyone on all sides of these debates and in both parties agrees that the Take Care Clause contemplates that the president may decline to enforce a law which he concludes in a responsible way is unconstitutional.
The gentleman's time has expired.
Mr. Chairman, I ask unanimous consent to introduce into the record the letter I referred to.
Without objection, so ordered. The gentleman from California, Mr. Issa, is recognized.
Thank you, Mr. Chairman. Mr. Lazarus, I hear you on the president deeply believing in his policy, his signature legislation, the Affordable Care Act. But he deeply believes, I'm sure, in every item that he wants appropriated from Congress. But 2 years later, it expires, right? And 2 years later, he can't just spend money unless he comes back to Congress for more money. Isn't that true? That's implicit in the Constitution?
You know, I apologize, but I don't really understand the question, Congressman Issa.
When the president's authority has run out, he must come back to the Congress for new authority. In the case of the Affordable Care Act, things which were not in the law have gone wrong. This act, this 2,400 pages that had to be passed and then read, has flaws in it, and these are fatal flaws if not corrected. Isn't that so? Including the absence of an answer to how do you subsidize if, in fact, a state chooses not to do it. Mr. Rosencrantz, if the law does not give the president authority and something goes wrong, I'm presuming that the framers always intended that you would come back to the Congress to resolve that need for additional authority. That it's happened. It was earlier mentioned Abraham Lincoln came back to have his suspension of habeas, attempt to have it ratified, because he knew he didn't, even if he did it by executive order, he had limited jurisdiction. He wanted to have it codified. I think a good example would be MacArthur's promise in war. They came back with the Rescission Act in order to undo some of the promises that were made in war to the Filipino people and so on. Is there anything in the Affordable Care Act that is different than any other time that something that's not in the law occurs, that's outside the law, that you come to Congress and say, I need authority to do X? Please.
I quite agree, Congressman. It's really quite startling that this Congress, this House, offered to ratify exactly what the president wanted to do, actually passed a bill which would have delayed the employer mandate exactly as the president wanted, and far from welcoming this, the president actually threatened to veto it. To me, that's quite startling.
Well, I want to go through a couple things I think we can all agree on and get to something Mr. Turley said. Would you all agree, without further pontificating, that when Andy Jackson heard from the U.S. Supreme Court that he had no right to move Native Americans out of their homes to Oklahoma, and he then did it anyway, saying essentially to the Supreme Court, you have no authority, you have no army, therefore I'm doing it, that he was outside his constitutional authority? You'd all agree to that. Let the record show I had all...
Certainly would agree to that.
Okay, I had all shaking heads. When Richard Nixon tried to withhold his tapes, which were essentially evidence of his complicity in the Watergate and the cover-up, and the court ordered those tapes, even after he'd fired a number of people and so on, you'd all agree that the court's action was appropriate, that there was a crime, it went to the White House and ultimately led to Richard Nixon resigning. You'd all agree that it was appropriate, I assume, for the court to intervene in this constitutional dilemma of a president that didn't want to turn over evidence related to his crime. Would you all agree?
I would.
Good.
I did.
And would you all agree, maybe, maybe not, that when the President Bush asserted in the Harriet Miers case, and this was referred to earlier, that when Judge Bates essentially said Congress has a need to get people in front of it, whether that person speaks or not, ultimately and this is Mr. Conyers' case, that in fact the court intervened and said, yes, I have a right to decide and you must produce witnesses. You'd all agree that that was a good balance of power decision by Judge Bates. Is that correct? In George W.'s case? Okay. Then on what basis does President Obama say he's above the law when in Fast and Furious he asserted that the court had no right to even decide whether or not a lawfully delivered subpoena should in fact be complied with? And in this case, Judge Amy Berman Jackson has ruled that, yes, she has the right to decide it. The question for all of you is, if we cannot go to the courts as Congress with our standing after a contempt vote, if we cannot go and get the court to decide the differences between the two branches, then in fact, as some of my Democratic friends have asserted, the imperial presidency is complete. Isn't that the most essential item, that if in fact we don't have standing, if in fact the court doesn't have a right to decide, then the executive power is essentially unlimited? Mr. Turley, you've written on this.
May I answer?
I'd ask for that same 1 minute for full answering.
Without objection, the gentleman may grant 1 additional minute.
I certainly agree that that's part of the problem here, is that we've created a system by which presidents can assert powers that others view as unconstitutional. I think the president's asserting clearly unconstitutional power in this case. And then the Department of Justice proceeds to try to block any effort of judicial review. This administration has been very successful in that, largely on standing grounds. And so there's no ability to challenge these things, even if they're viewed as flagrantly in violation of the Constitution. I'll also add, with reference to your earlier point, one of the things that the courts say when those of us who represent members go to the court and say the president's acting unconstitutionally, we hear this mantra from the judges saying, well, you have the power of the purse. But in this case, is the power of the purse is being violated. We have hundreds of millions of dollars that are being essentially shifted in a way that Congress never approved. And so we have, in many ways, the perfect storm. Even the power of the purse that's often cited by the courts really doesn't mean much if the president can just shift funds unilaterally without any type of review.
Anyone else?
I guess the only thing I would say, and I don't claim to be an expert on standing, as I think some of my co-panelists.
I'm more interested in a standing of the court, which was the question. Does the federal court have the right and obligation to make those final decisions on essentially balance of power? And if not, aren't we doomed?
Well, I just say two quick things. I mean, first of all, the courts do not have authority. They have authority under the Constitution to hear cases and controversies, and the courts do not have constitutional authority to decide matters that don't that are not cases or controversies, and that's why we have standing rules. The second thing I just say, Congressman, and also
so refusal to comply with a subpoena would not be a problem. Therefore, Nixon should never have resigned because his tapes never would have been discovered. In your example,
I don't think that follows.
He didn't turn them over without being ordered to.
Yeah, he might have. Well,
Mr. Rosencrantz, final.
I guess I'd just say some of the standing questions may well be tricky, but again, the ultimate check on presidential lawlessness is elections and, in extreme cases, impeachment. But elections primarily should be the check.
So when the IRS prevents the word from getting out by conservative groups, they in fact thwart the election. Therefore, elections are no longer the final answer, are they?
Right. To the extent that the IRS targeting is an example of discriminatory enforcement, you're quite right. It's actually the most corrosive form of Take Care Clause violation because it does cast doubt on everything that follows, casts doubt on the elections that follow. So you're quite right.
Thank you, Mr. Chairman.
The gentleman from Georgia, Mr. Johnson, is recognized for 5 minutes.
Yes. Thank you, Mr. Chairman, for holding this very important and significant hearing today. When I get my notes squared away, this hearing is pure political theater. It's a farce, plain and simple. It's a comedy, but the audience has seen it so many times now that it's no longer funny. In fact, this hearing is an egregious waste of this committee's time, especially when one considers all of the legislation that remains unaddressed by the House, like immigration reform. The Senate has passed comprehensive immigration reform, but the Speaker of the House continues to refuse to bring the issue to the House floor. Yesterday, as House members walked down the Capitol steps on their way home from an exhausting 1-hour workday, I watched as most members had their heads down. They wanted to avoid eye contact with the 50 or so young people standing at the foot of the steps in the cold wind. They had their hands clasped together, the young people, in prayer. Their prayer was on behalf of those families of immigrants that are being destroyed as a result of this nation's failure to pass comprehensive immigration reform. Their prayer was a simple one, that Speaker Boehner allow the House to vote on comprehensive immigration reform before the end of this session of Congress. The spectacle of those kids shivering in prayer in the cold last night could not be avoided by the members of Congress. So most kept their heads down, probably in shame, as they hastily escaped to the safety of their cars. I suggest that this committee hold a hearing on the question of why, despite immigration reform being supported by a majority of Americans, having been passed by the Senate, and the president having said that he will sign it if it ever gets to his desk, why is it that we can't bring that measure to the House floor for a vote? Mr. Chairman, this do-nothing House has only 7 days left, 7 legislative days left before it adjourns for its well-earned year-end holiday. The same Republican Party that has voted 46 times to repeal the Affordable Care Act is today, ironically, complaining that the president is not implementing the law quickly enough. But at its essence, this hearing, sadly, is simply a continuation of the majority's overwhelmingly obsessive and insatiable desire to kill the Affordable Care Act, which will enable 30 million Americans to have health care, 32 million Americans. 46 times they've tried and failed to kill it. The result of this hearing will not change the fact that Obamacare is the law of the land, and since today we are hearing testimony on the use of executive authority, let's not forget that the key authority for Congress to check the power of the executive is its Article 1 authority over appropriations. And by the way, this Congress has not yet passed a budget. Congress continues to shirk its constitutional duties under Article 1. Funding the government through short-term resolutions is not leadership, and the American people deserve better. So after holding yet another hearing to obstruct this administration, perhaps this committee can also take up the question of Congress's duties under Article 1 in a hearing entitled "The Congress's Constitutional Duty to Appropriate Funds." Now, as far as the Affordable Care Act is concerned, the individual mandate is constitutional. It will reduce costs, prohibit discrimination against patients with pre-existing conditions, and extend coverage to the uninsured. It will extend coverage to 32 million Americans. The individual mandate is the key to this legislation being successful. It would ensure that millions of Americans will not have to worry about being denied health care because of a current medical condition or fear that their coverage will be capped if they get sick. To the members who have served longer than I on this committee, I invite you to look back to 2003 when a Republican-led Congress enacted the law creating the Medicare prescription drug program. Most Democrats voted against the bill in 2003. The program was also very unpopular with most Americans, but Democratic members worked hard when the program was implemented in 2006 and 2007 to make sure that their constituents received the full benefits of the program. It's unfortunate that the Republicans today are not doing the same thing. Mr. Lazarus, this is not the first administration to temporarily postpone the application of new legislation. How have prior Republican and Democratic administrations treated the implementation of statutes when statutory deadlines become unworkable?
Without objection, the gentleman will have 1 additional minute to allow Mr. Lazarus the opportunity to respond.
I'll try not to take the whole minute. The answer is that prior administrations have done just what this administration is doing because they have to. I quoted President Bush's Secretary of Health and Human Services, Michael Leavitt, in saying that the president's current decision to delay the employer mandate was wise, and he said that and then cited his own experience in phasing in Medicare Part D, the prescription drug benefit program. The Environmental Protection Agency, under all administrations, faces statutory deadlines that cannot be met. We all know that. The Bush administration was often chastised by environmental groups for missing statutory deadlines, and the environmental community charged in court, in fact, that the Bush administration was using delays as a cover for simply suspending the law as a de facto matter. I don't know what the basis for that was or was not. And of course, again, if a president refuses to enforce a law for policy reasons, that is a violation of his take care duties, but that's not what's going on here.
Thank you. I yield back.